This is Irina Shea with part of our Wealth and Wisdom video series. Today, we're going to talk about what is the Secure Act 10-year rule in the context of estate planning. So I'm going to share my screen here with some ideas. So, what is this all about? So most people's balance sheet have very large IRAs, 401ks, 403bs. It's often their largest asset class, right? So how we handle them as part of the estate plan is extremely important. Pre 2020 was typically spouse then children. Spouse got lifetime stretch and children got lifetime stretch. So this was great. If you have children who were in their 20s, you're looking at 80 years of income tax deferral and stretch before they would have to take out RMDs. Um, Unfortunately, that changed. So in 2020, the Secure Act came into effect and it says spouses still get their lifetime stretch. Okay. But children now have a 10-year stretch. So what does that mean? So if you leave your large IRA, $2 million to your spouse, it's spread out over her surviving lifetime. But when she later dies and names the two kids, they have to take it out over only 10 years. So most take it out over 10 years, spread over 10 years to minimize the income tax hit because otherwise they take it all out in year one and they could be in the top bracket right away. So most people spread it out over 10 years. When you have a blended family, this gets even more interesting because maybe you were thinking, well, I'm going to leave some money directly to the children of my first marriage, so they're not waiting on my second spouse to die, et cetera, et cetera. But they do have to take it out over 10 years. So we always consider the income levels of spouse and kids. If you have a really super successful superstar adult child who's already in top income tax brackets or living in New York City, where just triple taxation, federal, state, city, et cetera, they may not be ideal for being a beneficiary quite yet, but timing also, or if a beneficiary is about to move to a no income tax state, then that is maybe good timing. So it's more nuanced than this, but at a high level, people should understand that the way that their retirement plans will pass to their adult children is not what it used to be. It used to be lifetime, now it's 10 years. So, and it comes out with income tax on the back end. So these are all considerations when putting together the puzzle of that particular estate plan, particularly where balance sheets of clients are now largely retirement plan, and the house and the brokerage are often smaller components. So very important to do this analysis. If you'd like to learn more, go to our website, irinashea.com, click on the Get Started tab. There are no charge for our initial consultations. Thanks.